reasonably sure that information is conveyed clearly, or I don't know, I would just wait, I'll have to ask Mr. Trin certain questions, direct my questions with him, but if any reason we might want to ask you a couple of questions to clarify his understanding or something, I think that's reasonable.
Precisely.
Okay?
Thank you.
Sure. Let me make sure I'm clear on why you're here, Mr. Trin. We had a matter where you were actually had entered into a plea agreement, as it's called. It's a way of resolving the case without going to trial. That plea agreement was both, it turned out to be the terms of the agreement were that there was a $170 payment that was, it was a fine that was assessed, and that fine is unpaid as of today. There's admitting 3 days of violation. Anytime there's a codes violation, the exposure is up to $1,000 for each day. We don't always impose the max fine, of course, depending on the nature of the violations. When you entered into this plea agreement, the fine was limited to $170, but the other 2 days of violation were set aside as long as you took care of the condition, then you wouldn't have any more money to have to pay. 170 was for a fine. There was 3 days of violation that you agreed, that you admitted to, and you were to schedule and pass inspection. Originally a June date, but was adjourned to a July 9th date. Mr. McGee reported to the court on September 12th that you had not yet complied with the conditions, which was to satisfy the, or take care of the violations. You have given me a lot of information in the past about, this is the understanding of what I have about what the violations were here involving removing all the property, the tenant being there. So Ms. Mack, just in case she wasn't here last time, doesn't know that I already had heard a whole long, you can see from my hand movement, it was really pretty long. It was a whole long discussion about tenants and telling them that it's their car, but you're the owner of the property, you have a code violation, you agreed to comply with the agreement and get those violations taken care of. And now we're here, and I'm not sure if we're here where there's good news that there's been some movement, or Mr. McGee is going to let me know that, to the contrary, that nothing yet has been done, and now he's looking for another step. So before I ask you about the $170, which is the straightforward part of the case, and before I can ask you any questions about the status of the conditions that you were supposed to take care of, meaning the condition is to rectify these violations, I'm certainly going to hear from Mr. McGee. But I'm going to ask each of you to provide your name on the record, actually, starting with the attorney for the city. May I have your appearance, Counselor?
Robert McGee for the City of Albany.
Very good. May I have your name, sir?
My name is Conrad Tran.
Okay, so that's what the court did, was to paint the picture, so to speak, of why we're here, Mr. McGee?
We are ready to move forward with the hearing.
Okay, and that is, the hearing was to be moved forward on because if you're not agreeing, I mean, the condition to be met is going to be shown by the city putting proof on that there is no passing of inspection that occurred. Mr. Trin, factually though, is that in dispute? Did you get to correct these violations?
I think I already told you. The bank called me not to go there anymore after June 1st. And they came there physically collect the rent. And the tenant said, I cannot go there or they're going to call the cop. So how am I going to go there and clean when I cannot collect the rent? Where do I get money to clean it? And where do I get the time to clean it?
You're still the owner of the premises, sir?
No, actually like 1 year ago. Now they try to get all the rent back like 1 year ago.
Are you still the owner of the premises, Mr. Trin? The last time we looked into this, you were...
Actually, that lot, I don't even own that lot. That was the city lot, the one violated. I showed you that, but you didn't even want to look at it. I don't think that's a fair judge doing something like that. I have to put up with that so much.
Mr. Trin, I'll just accept that you have a lot of frustration right now, and I'll just accept that you gave me 3 issues to address. The one is the bank is not able to tell you something like you can't go and hire someone or to get.
They say I'm not responsible for it too. I call them, they say, yeah, you're not responsible.
I'm sorry to say, but a lawyer involved with a prior case in here has let me know that he is still the owner of these premises, and we went over that last time. A lawyer sometimes comes involved in these cases because Mr. Trin is missing the mark on 3 different ways. You don't listen to the bank foreclosure person, you don't listen to the tenant, you don't listen to any of those people that don't have the authority to tell you what the law is, what your requirements are.
No, the bank is the owner. I have to listen to him.
No, but that's the main question. You were not proven, you did not show, unless that's changed, that the bank could be collecting rent in a foreclosure. It doesn't mean the ownership has changed yet. The bank can tell you, that's foreclosure law, that you no longer get to collect rent. The bank cannot tell you that you can't go to your property, either yourself, a friend, another person that you hire, and clean up the property, because you're the one who's on the hook for violations. So we will go through this hearing, so I can formally, after I think if I have any other cases on it for today, I don't know if this is anyone left to proceed with a hearing.
There is one other.
Right. So right after that, one other, which is either going to tell us the hearing to go second. If it's a resolution, I'll do it first.
That one is a hearing, so
Okay.
but I think we have a few other hearings that were scheduled for today that we could work with to resolve.
Right, so there's 2 hearings, Mr. Trin and somebody else, right? Mr. Trin, we'll continue with your matter. If you've left it in my hands, then I will. And I plan to be fair and reasonable. And you may not see it that way, but I can assure you, I will be fair and reasonable. If you have proof that ownership has changed, you have anything you want me to show you at the hearing, you're going to get to show it to me today.
I got the summons.
I will look at that as well.
They sued me to get the rent like a year ago.
Mr. Trin?
It's ownership. It's ownership.
No. They have a paper.
Mr.
They
Trin, hello, Mr. Trin? I got something
Comment.
totally different for you to listen
Yeah.
to. When you have a seat and you're
Yeah.
sitting down and an officer's coming over and getting your documents when the hearing starts, that's when I can see them, okay?
Yeah.
But we have to start the hearing now. We're
Okay.
going to start the hearing now because
Then you
I'm
can
going to look at
present,
the you want me
you
to
can
look at
present
it.
your evidence. You can
Okay?
present your evidence.
So
then.
Michael, you can prepare the tables for the hearing. We'll have, okay, 2 chairs over here to the right, you can bring them over to the tables. Thank you. Right where you are, Mr. Trin. Mr. Trin, that's your table, it's all you. You're all set. The clerk, don't be surprised, coming around to you now, coming around your back. There's a chair. Wonderful. You may have a seat. Miss Matt, I don't know, maybe you can just sit in the first row for now, thank you. And Mr. McGee, likewise, Michael has a seat for you.
Thank you.
I just want to make sure I'm clear on the order of business, that this is one of the hearings that's on for today, correct? And then there's a second person that's a defendant in the courtroom who also will have a hearing, and that one actually has to be up to maybe more than one witness, or at least one witness. Michael, now that we're beginning a hearing, and then again, you're going to be marking exhibits and different things. What's your location? You're fine where you are, probably, right? Location to give the exhibits to the, and be there since 5 o'clock. I don't think we for anything to say. Do you? Right. Do you have the stuff you need for the hearing? The exhibit tabs and everything else? If you do, we're all set there. So, Mr. Tripp, one of the things you wanted me to show you, Officer, thank you, Officer, one document that you marked that, that's going to be the what page, it was like a computer printout? Okay, yep.
I got the auction sale paper too, so.
All right. Why don't we take all 3 papers, okay?
And this,
Yeah, that's the foreclosure. What's it, that's the,
that's they gonna sue me to get the rent like
Okay.
1 year ago.
that's different than ownership though, so I don't need to see that, Mr. Trin. They're suing you to get the rent, okay. Thank you. I don't see that.
If I'm the owner, why the bank collect the rent? What kind of system
Do you
is
not
that?
know about the foreclosure? You're going to ask me questions today that have something to do that you should be seeking attorney help on, okay? I can't answer them all. I'm a really responsive judge, but I have my limits in terms of where I can provide helpful answers. If you're not,
It's a common
if
sense.
you're an owner of a property, may I just
Yeah.
say without having to raise my voice and over talk you, if you listen, I can talk a little lower, and that's better for my vocal cords, actually. I guess I gotta look out for my vocal cords, because no one else will do as well as I can, right? If you have questions about foreclosure, you hire an attorney. If you think the bank is not doing something correct in a process, you check with your attorney. Within foreclosure law, a bank might very well be looking to have the right under law to collect rent directly. That's the general information I can give you. That is not what is issued in today's trial in terms of this specific issue. Here's what I'd like to set up for the parties even further, now that we transitioned from a bench appearance. Do we have a settlement? What's going on here? Is there compliance? No, there's not, Judge. Mr. McGee says we need a hearing. Here we go. 3:03, 45 seconds, we're on to the hearing. This matter involves the City of Albany versus Conrad Trin. There was a plea agreement in which Mr. Conrad Trin, will take judicial notice, entered into an agreement back on May 24th of this year that he was to pay a $170 fine. That is an outstanding issue, has not been paid. That is part of the court's decision at the end. That's undisputed. I'm sure it's going to be just covered, though. There's no proof of payment, and unless there is one that you present, Mr. Trin, you owe $170. And I have to put you under oath to give testimony. Mr. McGee is going to start off the hearing by, I guess, deciding whether he's going to, first of all, is there any witnesses you're calling us?
Yes, Judge, we have one.
Okay, so actually, I guess that is the reason to, we need to, Okay, I guess another way to do it, we'll over here, and then I guess what you'll do is just slip out that way if you need to do it, if someone wants to approach the mark. So, there is a condition that was to be met, schedule and pass inspection. Mr. McGee is going to present the information to the court. He's going to say violations either still exist, action was done or not done. Ultimately, at the end of this hearing, after I have to weigh what I think happened here, is the violation still there? You might put some defenses on, according to you, things of ownership issues, having to do with your opportunity to take care of complying with this, which we've gone over informally in a couple of, well, not formally, but it was before the hearing. I emphasized to you that you have this obligation, and I didn't have an information that you were relieved of that obligation. If you have an obligation that you didn't meet, it allows the City of Albany to ask the court to impose a consequence for you not following the law. If they don't show that you violated the law, then there won't be any additional consequence. There still is that $170 payment that you signed up to pay back when the court made a determination that you weren't the owner and didn't have any opportunity to come out from obligation. You entered into the agreement knowingly and willingly, and that's where we left things. Mr. Trin, in addition to these documents that you have today, when you give testimony, if you have any additional documents, you'll certainly be able to describe what you have, and I'll make a decision on whether we need to see that as relevant, okay? Mr. McGee, in a moment, I guess you're going to begin by, Michael's going to drop over here by the computer, and you're going to leave the witness stand available for your first witness, and that's how you want to begin. Is there any preliminary other information you need to share with the court before we begin with the testimony?
No, Judge.
Very good. You may call your first witness, Mr. McGee. We'll give that back to Mr. Trin, that's fine. Mr. Trin will give some testimony about that in a little bit. Very good. Mr. McGee, you may proceed.
Good afternoon. I would like to call Josh Gold to the stand.
Okay. You may approach the witness stand. You may be seated. Good afternoon.
How are you?
Very good, right. You're here to give testimony on behalf of the City of Albany. I'm going to be, as you know, from testifying previously in court, before you can give testimony, you must be sworn in. So we'll have the document we need for the swearing in. You all set with that? Thank you. Please raise your right hand. State your full name for the record.
Joshua Gold.
Do you swear the testimony you provide this matter, Mr. Gold, will be the truth, the whole truth, and nothing less true, so help you God? Very good. If you don't mind just moving that microphone a little closer to just in case. And actually, Mr. McGee, as you're standing there, I want to make sure you're being picked up. I have a feeling that with the microphones like this, we're not.
I can talk from over
It's not
here.
as easily able to be picked up.
Yeah.
And everything is recorded. Okay, so you may proceed, Mr. Trin. If you have any questions afterwards, we'll go second. Thank you.
Okay. Good afternoon, Officer Gold. My name is Robert McGee. I'm an attorney for the City of Albany. Is it true that you're a code enforcement officer for the City of Albany Buildings Department?
Yes, I am.
And are you familiar with the property located at 530 2nd Street?
Yes, I am.
And have you inspected that property?
I have.
When were you last at 530 2nd Street?
August 22nd, 2018.
Okay. Do you have an opportunity to perform a full inspection of the exterior of the property on that day?
Yes, I did.
All right. Are you familiar with the notice of violation that had been filed in this case?
I am.
Okay. Okay,
Good, you may approach Michael, we'll be able to, what are we using for the City of Albany's exhibits, numbers or letters, Michael?
Numbers.
Right, so that'll be exhibit 1, so marked in a moment, thank you.
So I'm handing you as the marked city's exhibit 1. Would you please describe what that document is for the record?
Standard court document with a notice of violation.
All right. Now, referring to the notice of violation, is that the notice of violation that was issued in this case?
Yes, it
And
is.
and are the violations that are at issue in this case listed in that document?
Yes, they are.
All right. So I'm going to go down to each one of those violations. I'm going to ask you whether or not that violation was open as of your inspection on August 22nd, 2018. So the first violation of New York State Property Maintenance Code 302.1, where the corrective action was the exterior property must be brought into compliance with this section, must remove all garbage and debris, numerous bikes and bike parts, numerous bottles and cans from the driveway and in front of the house. Has that been taken care of as of the 22nd?
Those violations still exist as of August 22nd.
Okay. And so for the second violation of New York State Property Maintenance Code 302.3, where the corrective action was, I'm going to summarize, must remove all garbage and debris, numerous broken bikes and bike parts, and numerous bottles and cans from the driveway and in front of the house. All unused and non-functional equipment must also be removed. Has that violation been taken care of?
Those violations still exist as of August 22nd.
Okay. And then referring to the third violation of New York State Property Maintenance Code 302.8, where the corrective action was all inoperative or unlicensed vehicles must be removed from the premises. Non-working, unregistered vehicle must be removed. Has that violation been complied with as of your inspection on the 22nd?
That violation was complied.
Okay.
It was, right?
Yes.
Okay, gotcha.
And there were no inoperative vehicles on the property at that time?
Not that I was able to see.
Okay.
And what was the area of the house that you looked into, what property?
I was able to see the driveway of the property and the front.
Thank you.
This time I'd move that City Exhibit 1 be accepted as evidence.
I also can you provide that to the defendant, please, and we're going to have a look at it, make sure. This is actually, this is a court record. This notice of violation comes along with the charge. You would have seen that before. Can you take a look at that?
Look at it. Oh.
Just take a look at it. Say your name on it, make sure we have the right document, the right case, other than that, which is definitely a basis to not, right? So I'm going to receive that as part of the record of why we're here today, the violation that you've been served with previously more than once. Fine, I will so receive it. Thank you. Officer Gold and Officer Burke for passing that over to me, Officer Gold. Thank you. So receive. Right. You're done with this document you don't need it back for the witness, do you, Mr. McGee?
No, I do not. So that's all we have, Judge.
Okay, that's fine. Is very good. In terms of the ownership issue that's going to come up, I'm sure by Mr. Trin, is Officer Gold going to have any role in that discussion?
No.
Okay. Actually, before I should say you should step down, I'll obviously see if Mr. Trin has any questions for you. Mr. Trin, you heard the testimony of Officer Gold. The first name again is Joshua, right? Just wanted to make sure because I always had a question about that myself. I thought it was Joshua, I just make sure. There is the testimony that of the 3 violations that were at issue and the ones that you committed in your agreement to take care of by a certain date that has now come and gone, that date, that the 2 out of the 3 are still outstanding, having to do with garbage, debris, sidewalk area, and the exterior areas. And so, that was his testimony. It was the removal of a unlicensed or inoperative vehicle. Actually, I was very happy to hear that, because that had been a sticking point before in your discussions before the bench. Questions, if you have any. Now would be the time to ask Officer Gold. Do you have any questions? Do you have any questions? Do you want to ask the witness or no questions? We're
No,
going to go on to your testimony next.
I did call the bank, try to get him clean it. The bank say, no, you're not allowed to come in.
I'm so sorry, excuse me for interrupting. I will put you under oath. You will tell me your testimony.
Yeah.
This is a question time. Do you have any? You may not have any questions for him, but the questions have to be asked of the officer.
No.
Can I ask a question on his behalf?
How about you tell them what the question you think you should ask?
Can you ask them if the tenant was at home
Yeah.
and because the tenant is feeling that these are his possessions and you taking
So
them...
the second part I'm overhearing wouldn't be for him to testify
I
about
see.
whether the tenant's in possession. That might be his testimony that he wants to bring forward to the
Okay.
court about what conversations he had with his. But I overheard you saying you'd like the question to be asked just whether the tenant was home during the time of this August 22nd inspection. You want to ask that question, Mr. Tripp? You can ask him that question.
I told you, I no
No,
longer,
sir, I don't.
I'm not allowed to
understand.
go there.
You're not allowed to.
The tenant
You're
gonna
not
call
allowed
the
to give
cops.
testimony
No,
right now.
just ask. Was the
You
tenant
have a
there?
question for Mr.
Just
Officer
ask him if
Guo.
the tenant was there. That's all.
Because I got no mail from it.
Okay. Conrad, okay.
So I don't know what they were.
I appreciate this, Ms. Mack is trying to provide you assistance, and she's trying to
We're going
suggest-
to, it's not an important question.
She's trying to
'Cause-
suggest you ask the question of the witness, not of me.
No,
Do you
it's
have-
okay.
You want to ask the witness a question?
I guess it's
No,
not important.
How
It's
about-
not important.
How about, Mr. McGee, would you object to the, because, with him being pro se, and maybe it's not, it's a relevant enough question, any objection to the court's inquiry as to that issue of the tenant?
No, Judge.
Tenant, let's get the answer to the question.
Okay.
Why not? So many things that go on in a case where it's pro se, and there's people that are here that aren't the lawyers, and all the other things. And I do my best to draw the line, or walk the line. So I'm going to walk the line this way. I'm going to give, out of deference and respect to people in general needing to try to put the puzzle together, the pieces
Yes.
together. Let's ask the question.
Thank you.
Why not? You're welcome.
Guess the
Let's
question-
go. Probably not the question, like drum roll. Here we go. The question is, was the tenant, if you assume there are tenants living at this premises, were any tenants home on your August 22nd, 2018 inspection?
There were people outside the property, but I'm not clear if they were the tenants or not.
Did any kind of communication transpire
There
between
was
you?
no communication.
Can we ask how many people were there?
I mean, anywhere from 5 to 10 people were outside the property.
Yes, okay.
Okay.
It's intimidating.
I'm sorry, did you, I didn't know what you said at the end, but I appreciate that you got a chance to ask the question, Ms. Mack. and
Okay.
That was the answer.
Thank you.
That's all I'm considering, is the answer and the question. Any other commentary? Thank you. Mr. Trin, if you have no other questions, then he's going to step down and you're going to give me your testimony, okay?
Yeah,
You ready to give your testimony?
yeah.
And other than that, Mr. McGee, anything on redirect?
No, Judge.
No redirect, the cross-examination is over, Officer Gold, you may step down. Thank you. Moving into the next part of the trial, thank you, Michael, for noting the trial record as being oath be given to Mr. Trin. Mr. Trin, you can stay seated, you can stay right there, it's fine, seated or standing, but you want to give testimony here, right? Unless you want to come up here. You're comfortable there?
Yeah.
Fine, thank you for raising your right hand. Please state your full name for the record.
Hi, my name is Conrad Tran.
Do you swear that the testimony you provide in this matter will be the truth, the whole truth, and nothing less than the truth, so help you God?
Yes.
Good, so I'm very curious about this legal ownership issue. Mr.
Yeah.
McGee might make a legal argument later about whether or not the status, if there is proof of a status and ownership change, that may have a bearing, it may have an impact. So why don't you begin with that, so that's a very important legal issue before we get to the facts, so to speak. What is the information you want to share with the court as to whether or not the ownership of this property is no longer with you, or perhaps with the bank? What do you want to tell the court?
I got the summons sue me to get my back rent that I collect, but I have difficult collect too anyway.
All right, what time frame? What year? What month are we talking about? It's probably dated, maybe a filed date. Might be
Like
something.
1 year
Just wanna
ago.
get a context of this
Somewhere,
lawsuit. You take them over
September.
Of what year?
Oh, wait a minute. That's a court date.
Your Honor, I'd like to speak again.
No, you're not speaking. You want to go forward and you want to point to the answer where the date is in the document.
Okay.
Oh, right here, receive it. From November 2017, that they want to collect the rent. They say, I'm no longer the owner, so I'm not supposed to collect the rent.
The
So
document that
they
you're
try to
referring
sue me to get the back rent too.
Okay, they try to sue you, that's your testimony.
Yeah.
The bank tries so you can take it.
Because
Is there a
I'm not
date?
no longer the owner by November.
I'm trying to figure out the
No.
answer to that question, if you're the owner.
It's November
Excuse
2017.
me, Ms. Mack, you can point out to Mr. Trin, if you're helpful at all in that regard, where he can answer the court's question by looking at the documents and he can give testimony.
That's the answer.
Since he's under oath,
Yeah.
he's the defendant, and he needs to testify. Thank you. Do you have a date on which which date?
November 2017.
Okay, it was a lawsuit for back rent, right?
Yeah.
And that's the first piece of information you want to say. Okay. There was another document you got marked, right? What are those? Exhibit A, I think. You got back to you, right?
Yeah,
Or
this
maybe you
one,
have it,
this one like a court
no,
day.
that's
I
not
have.
what I meant. I'm sorry. It's the one you have. Can you flip over? Can you flip it over? Just not make sure you're all set to sit back down.
Okay.
Thank you. That's the one right there, right? Was that exhibit? Well, just flip it over for me. Get to the first page, right?
Yeah.
Okay. Do you see that blue sticker on the, over there?
Yeah.
What's the exhibit number on that, sir? Exhibit A?
A.
Right, defendant's first exhibit A. What other documents, it's a 3-page document, before we let Mr. McGee look at it and voice any objection or no objection to it being received into evidence, what are the other documents that you bring here today on this issue of ownership, I gather? What else you got in that packet, in other words?
This is, they sued me, I have to go court day. They say I no longer own them since November.
I guess that has to be marked, right? Yeah. You know what, Mr. Trim?
So you
can
don't think
approach-
that's important?
That's not the A, but we're gonna make it B. Can you come around to see the clerk with that document, please? You really didn't want me to see that one. I thought I addressed that earlier. Can you, 2 pages, right? Yeah. I'll take a look at it again. It was for the back rent, right? Yeah, I remember now. We'll still mark it. We'll see if it's, we'll see what Mr. McGee's response is. Good. But in the meantime, yeah. We'll get back to you. You're gonna tell me about A, though. Let's talk about A, please. Can you give Mr. McGee B? You can give him that one? Thank you, Mr. McGee, if you don't mind looking at that. Tell me about A, Exhibit A. Page 1, page 2, page 3. What do you got there, sir? What is that? How does that help your case here? What is that? What are those documents referred to?
They say within 30 days for the sale of the building that they post that, that note they sent it to me is March 20 of 2018, and it said within 30 days is for the sale of the building.
Okay, so the sale hasn't happened yet. So as of what date? March, you're still the owner, right? Just so you know. What's the
Yeah,
date on
yeah.
that? March of 2018, right?
Yeah.
They could be looking for rent from you, but if they haven't sold it yet,
Yeah.
they have it's kind of like sometimes a fiduciary role, like a executive role or a referee role. There's a whole lot of ways that people operate when they're trying to get money taken care of. But ownership is very specific. A sale has to happen. So that document, just for clarity, it's a little bit.
My lawyer told me the sale date is the last date I own.
The sale date hasn't happened as of yet, right? That's going to be coming up. That says it's going to be in 30 days. Do you have any proof that
No,
the sale
that's,
happened?
I said the note is posted March 20, 2018.
That the sale
Today
happened-
is August 23rd.
That the sale will happen in 30 days. Sales don't always go through. Something might have been extended. Do you now have a document that shows that the sale actually is a deed? It's real property. You need a document that is a sold property. So that's not going to be, it's helpful, but do you have something else in addition to that? That the deed was turned over, that you signed something, that the sale happened. Do you have a document about that?
No. No, I called the bank. I say the judge want me to go in there and clean it. The bank say no, you're not allowed to.
If you'd like me to take that into consideration as part
The
of your
bank
testimony,
say you're no
I certainly
responsible.
will. It may not be the most dispositive factor, but if you tell me the bank told you
I
something.
think you should go after the bank to get the money, not a deadbeat like me. It's gonna go nowhere.
Okay, that's also
It's a
part of
common
your
sense.
testimony. Gotcha, I got that part too.
Okay?
Yeah, the money is $170 fine and not meeting condition, we don't know what that money is gonna look like.
Because you pressure me to sign it.
I'm
I
sorry,
thought that's
excuse
the
me.
end of it.
Mr. Trent, this is not argumentative, I'm a fact finding, you're giving me information. Can you tell me what else is part of Exhibit A? This is factual matter you need to do, not commentary, you need factual matter right now.
About what?
What is the rest of your exhibit? That's the first page. What's the second page? Remember that page? You said,
The second
Judge,
page,
I want you to see. I'm so happy I saw it. That's the document you want me to see. I'm all ears.
The second page,
What is it?
it said the city owns it, the city bank owns it,
Fine.
not Conrad Trent
We'll look at that
since
too.
a few years ago.
Right? And what's the third page? Looks like a printout, the second page from the codes department
The
potentially.
third page
The
is,
second page, what's the third page?
they want to collect the rent from my tenant, that's something like that.
Okay, Mr. McGee, you already saw, I think you had a chance to look at the exhibit A already?
Mhm.
What's your, any objections that being received in evidence?
I object on the grounds of relevance. I don't think any of these issues matter. Mr. Trent has entered into an agreement where he agreed that he violated the code, he pled guilty. I don't think any of this ownership material has any bearing on the outcome here.
For the efficiency of the trial, in addition to that being your, the objection on the document itself, Mr. Trent, I want us to listen, you and me, very carefully. We both should have to, I'm listening, you should listen too. I'll allow this to be the part of what I said earlier, that he's going to have, Mr. McGee is going to have a legal argument to be made. Because you're saying ownership? Yes or no? If you are not the owner, in essence, you're saying, Judge, that means I shouldn't be responsible anymore. However, Mr. Trent, that's your argument. I got it already. I want to hear what the city arguments are. If Mr. Trent could even establish today that he's no longer the owner, whatever date that is, it's sometime, I haven't seen Exhibit A yet, but when I see it in a second, I assume it's going to show me the March, if I heard it right, the March 2018 date of a sale upcoming within 30 days, so that means that he's the owner as of March. We know that. This agreement was entered into on May 24th. Even assuming that there was some, the evidence is going to establish that he wasn't the owner. Even when he wasn't the owner when he entered his agreement, perhaps, and then later or afterwards. What's your position on how that affects the legal issue of whether a person who is a prior owner who entered into a plea agreement involving code violations, how does that affect his responsibility to legally be held responsible, I should say, for any and all code violations that existed at the time he entered into the agreement?
Well, if the property was sold or seized after the plea agreement was entered into, that would be relevant, but we don't have any evidence in these documents that was actually the case.
So, the objection, which I would think I would be looking at Exhibit A, taking it into evidence, is that is the fact finder decision for me to determine whether those documents establish ownership or no ownership. But to the extent that it could be, that there is a legal relevance to the question of whether he was the owner or not, I will look at what he has, and I can make on the weight of the evidence, it's called, not the admissibility.
Right.
I would make a decision. Yes, it shows what Mr. Trin is saying, or no, it doesn't. Just to expand on the legal argument, because this case is coming to a close sooner than later, he hasn't told me yet. I'll ask him if those violations, the two, have been met. That's the dispute. He might be agreeing that he didn't take care of them. I think I've heard that he already has told me issues like I couldn't go there and other things. So I'm assuming there's not really a factual dispute, that the Officer Gold's testimony is certainly factually correct, that I'm going to find likely after hearing from Mr. Trin. But legally, if there is any decision that I have to make here legally, it would be if he's the owner, how that would affect him. What would be the outcome if he had sufficient proof that he was no longer the owner after the plea agreement? What would be your position on there's a $170 fine, and then there's the additional days of violation that were supposed to be a condition met that you claim wasn't met yet?
It's hard to speak to that specifically, Your Honor. I think that would have a bearing on potentially being more lenient in terms of the actual conditions of the property, and tying your fine to that. I think that would come into play there. But I think at the end of the day, Mr. Trin accepted responsibility for the violations and promised this court that he would take care of them, and he didn't. Doesn't seem like he made any attempt to. Just speaking to the documents themselves, he'll also register an objection on the grounds of hearsay.
Very good. Okay. Mr. Burke, may I have Exhibit A, please? And what's Exhibit B that was given to you, Mr. McGee?
I don't believe I have that anymore.
Oh, yeah, that was when I was the two-page lost. You don't have any more.
Oh, there it is.
Did you have an objection to Exhibit B?
The same objection.
About whether that was relevant.
Yeah, relevancy.
I'm going to accept them both. Thank you, Officer Burke. I'm going to look at them now. Any other documents you have, Mr. Trin, on that shows, like a deed? You have a deed where you signed over the property to the bank? Now would be the time to present it.
Because I've been moving to the new location, so
Mr. McGee, I do want to ask you a question, take judicial notice of this Albany County Land Bank Corporation, this exhibit. You mark them, maybe this one was just marked A, right? The second page in. The second page. Land Bank, Albany County Land Bank. I see the date, it's a tax roll, 2019. You call that, I guess that's interesting. 69 State Street, it says. And we're here for 500, we're here for 530. Mr. McGee, there is that sale and foreclosure document, the Supreme Court Chambers. Again, it's not proof that the sale went through, but this is relevant, this one exhibit, to the question of ownership. The fact that the bank had started a lawsuit for judgment of foreclosure and sale of, I'm assuming, it doesn't actually have, I don't know where the property address is. Those would be the objections to the relevancy or the lack of foundation to receive a document that may not identify the property. Did you get as far as looking at this exhibit 2 that was a land bank and that the fact that the subject property was listed as 69 State Street?
Well, I think 69 State Street, if I could have an opportunity to look at that document, I might be able to answer that question.
Thank you. Yeah. So, Mr. Trin, as you're doing that, no, this is what you have for me to consider, right? You want me to look at this?
because the bank not going to spend money get the lawyer to sue me if they know they don't own the property to have the right to collect the rent.
Okay. I don't have anything in front of me that says you're not the owner yet, so I'm going to wonder if you have anything else to show me before I make a decision. But, okay, Mr. McGee, though?
Okay, well, this document, again, I'm going to say objection, but we have, this is referencing 532 2nd Street, not 530 2nd Street.
530 is a building, not a driveway. The man said the driveway to violate, not the building.
I understand we'll get to the issue of 530 and 530 22nd, but my issue about this, when I saw the 69, I think State Street, what's that? That's the address for the Albany.
Yeah, that's the address for the.
Gotcha. Is there a lot here that there's a difference between 530 and 532 he's indicating, I think there might be.
No, I mean, Officer Gold's testimony was that he went to 530 2nd Street. He observed that property and he found the violations at that property.
At that property, right? So, do you know anything about what 532 2nd Street is in terms of in relation to your involvement with this case? I'm just wondering if you are clear what the 532 is about.
No, it appears to be from this record a vacant lot. 31 by.
Can I adjourn my case to get a lawyer?
No, you cannot, because you had 3 opportunities to do so before today. That's why. That's a real definitive answer to your question. My question of you now is, thank you. Back to you. I have a question of you on Exhibit A. The second page, Mr. Trin, that land bank has to do with the lot. 532 is the lot?
Yeah.
Is that correct? Okay. It doesn't show that you're here for 530 State Street.
530, I told you. 530 is a building. 532 is the lot.
And what do you
That's
think?
where the violate and the driveway that violate the code.
Could we call Officer Gold for a minute?
Yes.
Officer Gold, perfect timing. Can you come back up into the chair, please? We got to do one last fact finding in this case that's relevant to the court's decision, for sure. Because I think I know what I have to do with respect to the ownership issue. Because I don't have any other thing definitive in front of me about that Mr. Trin's not the owner at this point. That's just a heads up, Mr. Trin, okay? I do have to get onto another hearing, too. So the other person's patiently waiting. We're about 30 minutes into one hearing, we're about to start another. Officer Gold, you're still on your oath and being recalled by the request of the court and consent of the prosecutor that There's a property, subject property is 530 State Street, I'm sorry, 530 Second Street in the city of Albany, and that there was Mr. Trin acknowledging that's the building. There's a discussion about a vacant lot, whether the address is 532 Second, it might be, but if there's, what you can describe obviously was the existence of, since you were there. Is there a vacant lot that exists, and if it does the violations, Exhibit 1, subject of this hearing, any of those violations pertain to the vacant lot versus the building, 532nd Street?
I can't testify if there was a vacant lot there, but I can testify that all of the violations are on the driveway or the front of 532nd Street.
Okay.
Not in a vacant lot.
Any other questions of the witness?
No, Judge.
Do you have any questions?
There is no vacant lot. That was the driveway. I don't know where you're looking at.
Mr. Trin, his testimony was?
The vacant lot is the
violations-
driveway, the front, the driveway.
The
The back
violations-
is just kind of empty
Do you
space
have a
and a
question,
shed.
Trin? He's saying the violations were pertaining to 532nd Street, that's his testimony.
Where did you see the vacant lot?
I didn't see a vacant lot. I saw the driveway of 532nd Street, which is where all the violations existed.
Yeah, the driveway is the vacant lot. Is 532,
Okay,
not
that's your testimony,
530.
that's not his answer, and then do you have a question for him? Any other question? You got one question, that's fine. Any
Yeah.
other question?
That's it.
Anything to redirect?
No, Judge.
Thank you. You're all set. Can I have the exhibit A and B? I'm going to accept them into evidence, and I'm going to judge the weight of them. There's no deed that you have for me, Mr. Trin, on ownership, right? Jane, no deed? I'm going to take a look at, I have actually exhibit B, thank you, Officer Burke. I'm trying to look to see if I see that any address. This is a lawsuit, right? Mr. Trin, this lawsuit was filed stamped with a court, Albany County Court. You're being told you have to show up in the Supreme Court so that you're not found to be. Your failure to appear in court may result in immediate arrest or imprisonment for civil contempt. That we know. July 31st was your court date for this case. The very evidence that you are showing me to say proof that the sale was already done, this is.
The bank not allowing me to come in.
Show up, right?
The bank told me not to come in.
Having to do with turning over rent, right? Wrongfully collected. For them to say that you're collecting rent wrongfully, there's an allegation that you were collecting rent that should have been going to them during the course of the foreclosure. But I can't take this as proof that you're no longer the owner or that they're the owner. I can't do that.
The bank tell me not to go there, do anything. So how am I going to clean it up?
Okay.
You don't even want to listen to that statement.
How about I read it
The
back
judge
to you?
supposed to be fair, not all about the power or the good lawyer.
I 100% agree with you. I agree with you.
If
And I hope not to meet
the
you,
judge like that, we might as well throw out the judge
If this was
system.
a law school class, I would.
They are the expend taxpayer for nothing.
But I want to talk about
Let's
you,
take
as
facts.
Ms. Mack is trying to have you focus. This is your interest on the line. This is the judge that you have that is listening to you. This is the first thing you just told me before. The bank told me, see how good, make sure I'm listening. Excuse me, Mr. Trin, gotta give me the respect that I'm giving you. Here it comes.
You gotta listen now.
Mr.
She
Trin
wants to
just
help you.
told
She
me-
wants to help you.
Mr. Trin, meaning you, just told me, meaning me, Judge Heath, that the bank told you not to go near the property, so how can I collect rent? That sounds like a defense you bring onto this lawsuit, number one, the one where they're looking for you to turn over rent, and you want me to take that into consideration. You know what my answer is? I'll take it into consideration. In my fairness and recent judgment, I will.
No, I called them. I say,
Anything else?
I need to go in to clean it. The tenant don't want me to clean it because all their bottle recycled.
Tell me about that.
And the tenant was, they collect bites so they can fix it to make extra money. They say, don't throw these my way, I will sue you. And the tenant say, you're not allowed to come around here to do anything. because the bank told us to call the cop if you hang around do anything. So how am I gonna clean it up? And I have no money to clean it up. There's like so much junk in the back. Or time. I've been looking for a job now.
Okay.
You
That
probably-
sounds like important for me to consider when it comes to the sentence and any penalty about tenants not allowing you to clean up things according to you, and that you have some financial hardship. I know where that fits into.
You're not gonna get any money from me because I'm
Okay.
broke.
I heard that, Mr. Trin.
I think you should go after the bank easier.
Okay, now the hearing has, good.
Legally, they own it too.
Okay, I think you've been.
It's just, you're doing wasting tax money for nothing.
Mr. Trin,
You
you're
just
not-
try to bully
Mr.
good
Trin,
people. That's not right.
Mr. Trin,
She heard you.
I could be vicious too if things don't work right.
Mr. Trin, Ms. Mack.
You don't think that, you don't
I'm
think,
sorry,
He's
what
very
is her
upset.
role
He's
here?
very
Was she
upset.
to try to give you some input? She was trying to give you some input.
no, I put up with you a lot. You're supposed to be fair
I didn't
judge.
say put up.
Please.
I said she.
You're supposed to be fair judge. It's not like walk all over
Okay.
just because I be patient and nice.
You don't know
Mr.
what her
Trin, you're not being
decision is.
patient and nice,
You
and
don't
I
know what
am.
her decision is yet.
Excuse me.
No, she lying about stuff that I said to
Mr. Trin,
her.
it's time to stop talking about
Please.
that because
This
it's
isn't
not
helping.
appropriate anymore.
Not helping.
No, she lying about stuff.
No,
Mr.
she
Trin,
heard what
I
you
am ready
said.
to hear from the closing remarks from each of you on this
She
case.
heard what you said.
I got your documents,
She heard you.
I heard what you said, and now it's time, financial. The tenants not letting you do the work that you might wanted to try to do, and what the bank told you. I'm giving you the respect of summing up for you what you heard, and I'm not I'm not addressing anything else that you said, because it's not relevant to this proceeding. And I'm being a fair judge, I guess I'll say that on my behalf. Very good. Mr. McGee, do you have any questions of the testimony of Mr. Trin? For Mr. Trin?
No, Judge.
Okay. Mr. Trin, you'll get to go first. Why do you think that the charge that you had pled guilty to for failure to comply with the notice and order that required you to do all these things from when the time you were, even before the foreclosure started, and you signed a legal agreement to do them, why should that not result in a consequence? What do you think you should
I might agree with that. That's because before the foreclose. But I thought was the end of it. But the city still have to reinspect and I still have to pay. But the time reinspect is after they foreclose that I can no longer collect. I can understand when I can collect the rent, yeah, I'm responsible for that. Because the tenants say that they're going to clean it up, so I take it for granted.
Okay.
That I can understand. I would just make a payment.
Very
That I mean, 200 there. I can understand that. I'll make a payment, you know.
Very good. I'm sorry, that's all that you can have a couple minutes for closing as we conclude the hearing. Thank you. And your attorney, Mr. McGee.
So we have an agreement here in which Mr. Trin accepted responsibility for the violations. He promised the court that he would take care of the violations. He didn't take care of it. We have Officer Gold's testimony to that effect. And based on all that, I would recommend the highest fine allowed by the statute.
Mr. Trin, I am finding you liable for having 2 violations that are not yet rectified. If you were to have no responsibility at all, it would only be because you could show me a deed. There is, unfortunately, maybe everyday person or a person without the benefit of lawyer input in a foreclosure thinks the word foreclosure means owner, no longer owner. It's not that. A foreclosure is the process by which you change ownership because you didn't pay your mortgage to the bank, and they come after you to take ownership back, and they start the lawsuit, even your own records, in this year. But your agreement is binding. There's a $170 fine. The foreclosure might be very helpful to the city's effort to get this cleaned up at some point when it becomes the bank is the one that owns it. Mr. McGee in his office can certainly look into any future code violations being lodged against or,
Because
fought against
all I know is the bank told me not to go
I'm
there.
going to be really clear now. You don't get to, I heard
Yeah.
the testimony, but you have to be quiet now, sir. I'm sorry. The bank is somebody, when they do become an entity that, if the bank is the owner, that the city can decide they need to bring a lawsuit against. That's their choice. But for your purposes, and for what you signed before me, and for what you have stood responsible for when you stood before me, it is for taking care of these violations. I find that Mr. McGee's office was very patient with you when they extended their time frame from June to July. It is now August. I find the testimony of Officer Gold to be credible. I am imposing a $500 fine. I'm glad the car is moved. The debris is the debris. It's not going to be as much fine money as Mr. McGee is requested for the exposure you had for the 3 days of violation. You have $170 fine outstanding. There's a judgment together with the $500 as a result of this finding of liability. It's $670. This case is concluded with the city being able to submit a judgment for $670. And the next step, I wish you well with your finances when you get on your feet. Don't forget to go to the Supreme Court to deal with these cases. I want to give you back your copy. It's the only copy you have. Michael, can you make a copy of this for Mr. Trin? And before you go, I'll take the next file for the next case. Mr. Trin, I'm going to have to ask you to wait for this map. Just gather up your belongings. We'll send out a written decision to follow up. I'm going to send it by the 13th of September. I'll mark the file line. I'll tell you when you come back. 13th of September, you'll have to pay $670 otherwise there'll be a judgment against you. September 13th. Thank you. You may take that first seat.
She was trying to help you.
No, she's lying. When she says something, she's lying. She's making me look bad in front of you too.
She was doing the law. And you don't know the law? You don't know the law. She was doing the law. She's a very impatient person. Yeah. But
yeah,
she was,
in some ways she's trying to help me too.
She really liked what you said about not being able to get on the property because they thought that these were their possessions. And that was, it was good that he testified that there were 5 to 10 people out there. Thank you, officer. Oh, good. Yeah, we're all good. I know he is.
Yeah, I got him here.
I want to go for Steve Smith. I was going to work for Steve Smith in the bar.
Ask her, she's my landlord. I pick trash around.
I know, he's a good guy. He's a good guy.
I wasn't impressed with her, even other property. I take trash and take care of the neighborhood. Yeah. And now she treats me like I'm criminal.
It's okay. She did, actually I thought she did
I know.
good Conrad.
You got a little nasty there. You can't do that.
She did. You can't call a judge a liar. You just can't do that and not be thrown out.
What do you live in?
He's not, he lives above our offices at 278 Clinton Avenue.
I'm behind Rand. You got something to me to let it borrow?
The Steve Smith guy is no good.
I know. And she let him to get leave. I had to sit there like 5 hours listening to him.
Who's Steve Smith?
He showed up with his stomach sticking out. I know. And it was me. She probably saying to him like I wasn't.
I got 10 more minutes on my meter. Let's go.